Hi, I'm Karl Konrad and welcome to Australia's largest immigration news channel, which does not parrot the news in AI voices. Here you will discover up-to-date reporting on migration law changes and, most importantly, an analysis based on 25 years of professional practice. This program is proudly brought to you by Australian Immigration Law Services right here in the heart of Sydney. A big milestone has arrived this week thanks to all of you. We have just crossed the 90,000 subscriber mark and rocketing up to 100,000 soon. It has just been over 4 years since we started this channel, and for a news channel I think we have done pretty well with just over 8.4 million views so far. Looking at some of my dorky earlier videos, we have come a long way. This net overseas migration, the NOM figure, being passed around in the media and by politicians with a degree of hysteria, just how accurate is it? This week I consulted with a client whose mother-in-law was recently refused an extension of her tourist visa while staying in Australia. Nothing unusual about that, so I thought. The refusal letter said she arrived in March 2003 and applied to extend her 12-month visitor visa in March 2024. The letter said she had spent more than 12 consecutive months in Australia and hence was not eligible to be granted another tourist visa without exceptional circumstances, and none were offered. And well, that sounded about right. However, when I spoke to the son-in-law, I got the full story. It turned out that his mother-in-law left Australia in December 2023 on the original tourist visa and came back on the same visa in January 2024. However, the Home Affairs Minister refusal letter clearly indicated they had no idea that she had not only left Australia but also come back in. Clearly the refusal should not have happened on those grounds, and the family has to waste money to appeal to the AET to sort it out. This is a clear example that the government records are inaccurate, and they use this inaccurate data as grounds for visa refusal. So then, do we really know then the amount of people leaving and entering Australia? How accurate are these NOM numbers? And that is a worry, since we are making monumental policy decisions that will have ramifications for decades based upon flawed capacity to register people's movements in this country. Something to look into further, so stay tuned. The petition for a transition period to be established for 485 visa holders over 35 years of age has had a terrific start. This week we have had over 8,000 signatures, and that is closing in on the 9,000 mark shortly. This was despite the e-petition government IT server going into meltdown over the weekend, and many people were unable to sign. They fixed it on Monday during the morning, but again Monday night it would not work. I can only assume that the overwhelming response was too much for it to handle, rather than the Home Affairs Minister sneaking in at night to switch it off. So please don't give up at night if it won't send you a verification email so it can be signed. Try again in the middle of the next day. Please, all of you who haven't signed it yet, the link is in the description of this video. It just takes a couple of minutes to e-sign the petition, and remember, it doesn't matter if you are a temporary resident in Australia, you can sign it. Now, that is the good news regarding our campaign for the transition arrangements. Unfortunately, now I have to share some of the bad. It seems the Minister Claire O'Neill is determined to carry out this mad scheme without offering transition arrangements. One of our regular viewers called Mark sent me an email during the week. It contained a response from the Home Affairs Minister's office about the transitional arrangement request. Now, Mark moved from the UK last year with his family to take advantage of the offer of a 6-year working visa after completing one of the advertised master's degrees. He will have spent over $200,000 in Australia by the time he finishes. He is over 35 and worried whether he will be given the 485 visa when he finishes. Unfortunately, the callous response he received from the Home Affairs Office was rather depressing. It demonstrated a Home Affairs Department devoid of any compassion, and indeed demonstrated a lack of understanding of the realities international students face in this country. They talk about visas as if they're selling a product, as if they were running a business but lack the experience of what it takes to run one. The letter states, The purpose of the age limitation reform is to reposition the temporary graduate visa as a product for early career professionals who can contribute to the Australian economy over a longer period. Based upon research undertaken during the development of the migration strategy, the age cap of 35 years or under will not disproportionately impact PhD students, as the temporary graduate visa is not the preferred pathway these students have been using to migrate to Australia. What utter nonsense! Firstly, it demonstrates they did not even read over Mark's circumstances, for he is not studying a PhD at all, and they completely skipped over the fact about the minister offering students the longer 485 visa if they begin these certain degrees. And thirdly, now PhD students may move on to use some other pathway to PR, but they certainly do use the 485 visa as a working visa when they complete their programs, just as Masters or even Bachelor and Vocational students. And the letter goes on to state, while the Department of Home Affairs is not able to consider individual exemptions for international students over the age of 35 for temporary graduate visas, graduates who have relevant work histories but are no longer eligible for the temporary graduate visa due to the age restriction will continue to have access to other temporary and migration pathways, which will be enhanced as part of the visa reform. The development of the new skills in demand visa may provide graduates who have extensive work histories related to their area of studies with a quicker pathway to permanent residency rather than the temporary graduate visa. So this is the type of government we are up against. Over a decade ago, before the Department of Home Affairs came into existence, the Immigration Department had a slogan, "People, our business." It was on the footnote of every official immigration document and all over their website, and there was even a client service charter. How sad those days are long gone. These days, the customer service model is just a distant memory, and the statements in this letter demonstrate how out of touch this department actually is. Firstly, the Skills in Demand visa is the same as the current 482 visa and requires an employer to pay a great deal of money to sponsor you. That figure is usually about $10,000 in total. Secondly, most Australian businesses have no idea how the process works and are reluctant to sponsor. And thirdly, even if you get lucky enough to find an employer to assist, they will usually want to see at least a full-time probation period before sponsoring. This, of course, is usually achieved on a 485 visa after students finish their courses. Listen everybody, this is going to be a tough battle to convince these ministers with limited migration experience that the logic they are spinning to justify this age limitation does not match the reality on the ground. Can it be done? One can only hope so. There are no other options here before us. We must fight for the basic shred of humanity to be given to these affected international students. Every single affected international student should be writing like Mark to the Home Affairs Minister and the Immigration Minister and tell them your story and why their decision is unconscionable. We often talk about invitation rounds and planning levels on this channel, but what do they mean and how do the two interact? And thank you all who have written in this channel and asked that question, as Kamar did. The planning level for a particular visa can often be potentially filled by the people who have lodged their visas in the previous year or perhaps even years ago. When an invitation is given out through the Skills Select system for a permanent residency application or provisional permanent residency application, it is likely that their visa will not be processed until the following financial year and thus falls into the next year's planning levels. So as far as the number of invitations that will be handed out during the next financial year, it really depends upon knowing the number of visa applicants still waiting for their visas to be granted at the end of this financial year. It is also important to understand that when an invitation is given out, it does not only mean one applicant will use it. Quite often a whole family will apply. Say 4 people using that one invitation. Let's go through the numbers of the 189 visa as an example. From the last Freedom of Information on the Department's disclosure logs, it shows that by the end of February 2023, still 31,449 applicants were waiting for their visa. Then came along in May another invitation round. In that round, 7,353 invitations were issued according to the Skill Select database. This means maybe about 12,000 applicants were potentially added based on the extra dependent family members. We can estimate that they may perhaps still have about 30,000 people on hand by the end of July 2023, since there should have been some grants to the end of that financial year. So for this financial year, 23 to 24, according to the planning levels, there are about 35,000 places to be handed out. However, in December 2023, another invitation round occurred of 8,300. So let's add a few more visa applicants based upon dependents and say another 14,000 people applied. You can see then that perhaps about all of the 35,000 places allocated for this financial year are probably taken. That's why there have been few grants in the last month or so. No doubt there will be a few thousand left over. But we only have 16,900 places based upon the planning level for this coming financial year starting in July. This will mean perhaps we may only get a couple of small targeted 189 invitation rounds in the next financial year, for the quota of the next financial year will be well and truly used up. We don't think the government will want many people still to be processed for the 189 visa when the new skilled independent visa category and the new points test are unveiled. If the new visa and points test begin at the end of this year, which is the most likely scenario, they will hand out invitations early next year for the new visa, which will probably not be still called the 189 visa. So the new visa may in fact use some of the existing 16,900 places for this financial year because it will still be a skilled independent visa. Now remember, the government is in election mode for next year. The Home Affairs Minister Claire O'Neill will want to boast how she fixed the skilled migration program with new visas, new occupation lists, and most of all, a new points test. This will be her crown jewels that only the Labour Party had the vision to fix our broken system. Therefore, it is crucial for Claire O'Neill to get this right and deliver it on time, for it may be a key factor to keep the Labour Party in power, since the Liberals seem to want to use migration as an election battlefield. Now for the state-sponsored visas of the 190 and 491 subclasses, we will have to see the quotas given out soon to be able to judge how many people are still waiting in the system to be granted. Stay tuned for that riveting news on this channel. And now, speaking of these planning levels, it's time to look at the processing times for May. For the 189 visa processing, it's up to 69 days. For the 190, it's also up a little to 12 months. For the 491 visa, a slight jump to 12 months. And the 191 visa has a slight increase to 90 days. For the 489 visa, it's staying at a very stubborn 45 months. The 887 visa slightly up to 76 days. And the 300 visa also stubbornly staying at 14 months. The 309 visa has risen to 16 months. The 820 visa up also to 13 months. And the 188A visa hovering at 34 months, where it may stay around there for quite some time. These processing times may slightly increase since there's very little visa grants happening in the next month, and we will revisit these times again in July. If you want to stay up to date with all the news, please subscribe to this channel and hit that notification bell. If you need help and advice, we are always here. You can book a consultation online, but if you're in a hurry, pick up the phone to see if we can make an urgent appointment for you. As always, take care out there, and I'll see you next time. So bye for now.